live. This is Law Call.
Hey, thanks for tuning in. My name is Les McFadder. I'm a personal injury lawyer with the law firm of Perry & Young, and this is Law Call. We are taking your calls live on the air. Tonight's topic is Ask Us Anything. So if you've got a legal question, whether it's about personal injury, property, anything, probate, family law, give us a call. Those calls will be taken live, 850-392-1544, or you can send us an email at lawcall@wmbb.com. And tonight, I've got my special buddy, my fishing buddy, my beard buddy.
I don't know if I like any of those things.
Yeah, the beard
Special
buddy.
buddy and beard buddy, those don't sound good.
Beard buddy, wait, let's take that back. Okay. You're not a beard buddy.
But I'm Brian Connors. I also work with Les at Perry & Young. We do personal injury, but we know a lot about quite a few topics.
I know.
So if anybody has any questions about anything, give us a call, 392-1544.
Yeah, and I think, usually we kick the show off with an email question. I do believe we have an email question from Natalie, if you want to go ahead and put that up. Okay, it says, my husband fractured his thumb and didn't say anything about it because he didn't want to lose his job. Now, 2 months later, his boss terminated my husband's job. He has pain at times because of the injury. Can he still file a claim on this? And that's from Natalie. So Natalie, that's a great question. It's very unfortunate about your husband. But really, anytime there's an injury that occurs on the job, people have workers' compensation insurance. I mean, there's some exceptions. There's some exceptions, but most workers are entitled, if they're injured on the job, to have their medical treatment paid for, and they get a percentage of their wages paid as well if they suffer an injury on the job. And that's regardless of how the injury occurred, whether it was the employee's fault, whether it was somebody else's fault. But there is a notice requirement. And under the statute, the workers' comp statutes are governed by Section 440 of Florida statutes. And I believe with very limited circumstances, you have to let your employer know about the injury within 30 days.
And you have to, when it happens on the job, it's so they know it actually occurred on the job.
Right. Yeah, so by statute, you're supposed to let them know within 30 days. Now, there are some very limited exceptions to that. I think one of them is if the employer was there to witness it. I think that's an exception. So they're on notice. There may be another exception, I believe, if you have some sort of an injury that you're not really sure what the cause of it was. It could have been something. These are more your exposure type cases where you develop a condition. I can think of people that might work, in construction industries. Maybe they get an injury or an illness due to some sort of an exposure. It's not readily available, but it is later then diagnosed by a doctor. Even at that point, once it's diagnosed as being something that might be work-related, you still have 30 days from that day. So with very limited exception, you have to let your employer know within 30 days of the injury. And I would encourage you to talk with a workers' comp lawyer to find out if one of those exceptions applies in your husband's case, because you mentioned it's been 2 months and he didn't report it. And look, for people out there that have been injured on the job, and employers out there, you can't fire somebody because they bring a workers' comp claim.
It's actually illegal to do that.
Yeah, it is. So it's unfortunate that your husband thought that, if I report this claim, I'm going to get fired. Because in the state of Florida, if you have an injury on the job and you file a workers' compensation claim and then you're terminated for that,
that is another claim.
That is an actionable claim that you can have against your employer for wrongful termination. So best bet is if you do have an injury on the job, report it immediately or as soon as you can. The employer then has a responsibility to notify their carrier. I think it's within a week, if I'm not mistaken. And then medical benefits are covered. Wages are covered. I believe it's 60% of wages are covered. And then, hopefully the person heals and gets back to work.
Yeah, and the only other thing I'll throw in, and for workers' comp claims, you do not get money for pain and suffering. It is just what we call economic damages. It's lost income, it's medical bills and things like that. But depending on how it happened, if he's on the job and another party hurts him, like we have people driving who are involved in car wrecks, and they have a workers' comp claim, but they also have a personal injury claim. So there's all sorts of things that you can look into when someone's injured on the job. But with a fractured thumb, sometimes there's medical treatment, sometimes there's a splint, sometimes there's nothing really you can do. Just kind of depends on the severity of the injury. But contacting an attorney whenever a legal issue pops up is the best advice that I'll give anybody. They can kind of point you in the right direction, or they can actually help you out.
Right. And Brian, you brought up a great point. I was going to bring that up, but you read my mind, I believe. we have cases all the time where people are injured on the job and they are covered by workers' compensation, but their injury was due to the negligence of somebody other than their employer or another employee.
Yeah.
Now, workers' compensation, the way the scheme is set up in Florida is it's considered no-fault insurance, basically.
Correct.
It doesn't matter, how the injury occurred. It's just if the injury occurred on the job, then the employer is responsible for providing coverage that will cover your medical expenses and your lost wages. The trade-off is that you don't get to sue your employer. Now, what if the employer acts with malicious intent and intentionally hurts you? That's different. They don't get workers' compensation immunity in those intentional acts. If you're injured by a coworker, like another person on the job, or maybe you're a construction worker and you're on a job and there's other subcontractors out there that don't work with you, but they're considered under the general umbrella or the general contractor's umbrella, you can maintain a claim against a coworker or another subcontractor, but you've got to prove that they acted with gross negligence, which is a higher standard than just simple negligence.
No, and that's why you need to contact an attorney.
Right.
There's exceptions where we can pursue claims, but most of the time when you are injured on the job, your remedy is
right.
Workers' comp is to make sure you get medical treatment, you're getting paid for your lost income, and you're not falling behind because you're injured on the job,
right.
regardless of whose fault it
right.
is.
And then, of course, the third exception, or not really exception, the third situation is when you're injured by a third party, somebody that you don't work with. It's not your employer. Think of a company driver. You're driving a vehicle and you get in a car wreck. You could be covered by workers' compensation because you're on the job, but you could also have a claim against the person that caused the wreck in negligence, and we handle those claims all the time.
We handle those all the time,
right.
and there's all sorts of weird things that happen with workers' comp and car wrecks. So if that ever happens to you guys, highly recommend contacting
at the end of the day, I mean, these are very nuanced, and there's a lot of loopholes that you have to jump through, and that's what we do. That's what we're trained to do, is to deal with these types of claims. So great question, Natalie. I wish your husband all the best in his recovery and hopefully finding another position where he's able to get back to work. But again, tonight's Ask Us Anything. So if you've got any question at all that deals with the law, give us a call. 850-392.
We're here to answer any questions.
Yeah, 850-392-1544. I'm probably going to say that number 5 or 6 more times tonight. We do personal injury. So that's really what we do at Perry & Young, is representing people who have been injured, whether they're auto accidents, slip and fall accidents, medical malpractice cases as well. Now, unlike the workers' comp situation where you have to notify your employer within 30 days, there's not a similar requirement in the personal injury scheme, although it's still very important to get legal representation early. Now, why is that?
Quicker. So number one, I think the most important thing is to make sure evidence is preserved. If you are injured at a store, we've actually tried a case. I think I've talked about this before, but the most important evidence is video evidence, whether it's at one of the big retail stores that everybody shops at, and making sure that is preserved, because sometimes that is the only way we can actually prove a store is responsible. Or if we're in a serious car wreck case, we need to go do downloads of the vehicle. We need to go look at stores, see if there's evidence of how the wreck happened, and we need to get all the computer data, which nowadays with smart vehicles or semi-trucks, I know you do a lot of trucking cases, there is an abundance of information that is out there, but if you don't contact an attorney, it's possible that stuff disappears and potentially affects your case. And I know you've had a couple of cases where it turned on video evidence that
Absolutely.
you guys have. And if you didn't have that video evidence or the downloads from the trucks, then we might not have a claim at all for our client. So I think that is the most important thing. And there's a lot of pitfalls and things that people don't know about. I don't have to get into everything, but we steer people in the right direction and answer all of their questions, negotiate the claims on their behalf, and make sure we get the key evidence, key witnesses, and stuff like that locked down right away.
Right.
Because as time goes by, evidence disappears, memories fade, and people disappear and move, and it's hard to find
Well,
them.
and not only that, but if you call an insurance company, if we call an insurance company well after the events happen, the first question is going to be, well, they can't be that hurt.
Yeah,
because they hadn't heard
nobody
anything.
notified us.
Right. So, I mean, it's just the optics on that can really kind of carry over into how a claim is adjusted. So, again, it's very important to contact an attorney very quickly once you believe you might have a claim. We actually have our first call tonight. It's Rob from Dothan. Rob, go ahead with your call.
How are you doing this evening? I was wondering if a citizen could sue the President of the United States if he caused all kinds of inflation, invited a bunch of illegal people in the country at our dime and our expense that we didn't ask for. I know that a lot of people are very upset with that and put us in all kinds of wars and jeopardized our whole nation. I wonder if it's possible if that could be done, or if there would be an attorney that would be interested in doing that.
So, Rob, I appreciate that question. I know there's a lot of frustration out there these days with everything that's been going on between immigration and inflation and things of that nature. It's made it very difficult for a lot of people in this country, and yet we still manage to persevere the best we can. The answer to your question is no, you actually can't, for what you mentioned, bring a claim against the President of the United States. The mechanism for removing the president set forth in the Constitution through articles of impeachment, and that's something that has to be introduced into Congress based on evidence, and then the evidence is then presented at the Senate, where the Senate actually has a trial,
yeah.
And then the Senate, they vote, and as you've seen, I think up until President Trump, there had been very few impeachments, and then we've seen multiple impeachments since then. So most people understand the impeachment process, and unfortunately, it has become hyper political, and you kind of know what the outcome is going to be based on how the Congress and the Senate is divided politically. But that's the mechanism. That's the only thing. And other than that, it's what we do in November every 4 years that really matters the most. And I only say that to say this. I registered to vote when I turned 18 years old, and I have never missed voting in an election. I've never missed voting in a primary. I've never missed voting in a general election.
How did you register to vote back then? Did you have to take a buggy and horsey
I
carriage,
registered to vote. I registered to vote. I went down to the Bay County Clerk of Court, and I registered to vote when Gladys Chapman was the clerk, and so I registered it, and so that's what we do. We make our voices known at the ballot box, and that's the process. And what's very frustrating for me personally is when you look at these elections and you see that we get 10% turnout, 15% turnout, 20% turnout. I think the election they just had out on the beach was under 20%.
No, it wasn't much. Yeah.
So I mean, I hate to say it, but you kind of lose your right to complain if you don't vote, and people don't realize the sacrifice that people made in order to give us that right. And I would strongly encourage you to go out and make your voice be heard. And maybe you can affect some change. If you don't like what's going on, that's how you do it. Get out and vote.
I agree with pretty much everything Les said. The only thing I'll add on is you do have the ability to sue government officials in some situations. But if it's like a discretion thing, like it's a policy decision.
Right.
Same thing with the state attorney's office. We've had cases, unfortunately, where the state attorney's office chooses not to charge somebody with, an offense that we think, could be proven, but we don't have any remedies for a prosecutor's discretion, a president's discretion, a governor's discretion,
right.
For their policies unless they're doing something clearly unconstitutional.
Right.
So policy decisions, just people disagree on those, but unless they're violating the Constitution, which again, I don't even know if there's a civil remedy filing a lawsuit.
I don't believe there is, so that's all the more reason to get out and vote in November. All right, Rob, thanks for the call. We're going to take our first break of the night, and again, give us a call. We're doing Ask Us Anything, so we're here taking your calls. Thanks for staying with us tonight. This is Law Call. We're taking your calls live, 850-392-1544. And the topic is Ask Us Anything. And so if you've got a legal question or really any question at all, just give us a call. We'll address it as best we can. During the break, we did get another email question that came in. I believe it was from Judy. Let's go ahead and put that up. Okay, it says, I bought a car on Facebook Marketplace because of work, which supposedly had been done on it, but it turned out it had not been fixed or not been done and cost $1,900 to get everything fixed. The original post talking about the supposed upgrades has been removed, but I have the seller's information. Someone suggests I take the seller to small claims court for breach of contract, fraud, false advertising. How do I do this? Okay, Judy, that's a great question. So Brian, you buy something, you buy a used vehicle, you buy it from a neighbor, you buy it from, on Facebook Marketplace, something online. The general rule is caveat emptor. Buyer beware. Buyer beware. My daughter's going to be proud of that, with throwing a little Latin in there for you, Rachel. Yeah, so, it's typically buyer beware. I mean, because when people sell vehicles private party, they usually don't do so with any sort of an expressed or an implied warranty. I'm going to say you this, and
drive it, and if you
take
like
it to a mechanic, you drive it, but it's yours once it's all done. Now, that being said, they can't give false information.
So that's where the email question kind of gets me. It sounds like they represent specific work was done. It was not done. So in that, I think you have I would say it's more fraud as opposed to
like a fraudulent inducement. You posted something false about it. It wasn't true. The person bought it.
And the reason you bought it was because of the fraud that was advertised.
Fraudulent inducement and detrimental reliance.
So there are remedies that you can have, but we run into certain things. I don't want to say it like this, but certain situations where is it worth it to go pursue the person? Because at the end of the day, if you file in small claims court and smile in small claims court, you can go get a judgment against the person for the $1,900 you spent. But if they can't pay you, you're wasting time and money. Where at the end of the day, if you can't go actually collect against the person, you paid money for a fancy IOU that won't turn into anything. So it really just depends. I have went to small claims court before, and it's surprising that some people, they'll mediate a lot of cases.
Every single case, I think, is mediated.
They mediate them right away, and it's not like the mediations where we do a big presentation. Usually the facts are, I don't want to say simple, but usually this simple. You misrepresented what you sold to me. I had to go spend this money. I want you to try and make it right. So it's probably worth it. I don't know if there are forms online. I think there are.
There are, yeah. You actually, for small claims court, it's really set up for people to litigate disputes without having to get a lawyer. I mean, lawyers are very expensive. Now we work on a contingency fee basis, so we don't get paid unless we get a recovery for our client, and then our fee is a percentage of that recovery. So nobody ever has to pay us up front. But if you hire a lawyer to go do something like a small claims action or county court action, they're likely going to charge you by the hour, and the hourly rates can be pretty high, depending on the experience.
Even if it's a couple hours just to file it, serve it, if the person doesn't.
Oh, you're paying more than what the vehicle is worth at that point. 5 or 6 hours in a filing fee.
And there could be. We don't really handle fraud cases, but I think there is potentially a fee shifting.
Yeah, there could be
statute for fraud where if someone is doing something like this, then they are responsible for your attorney's fees. But at the end of the day, you have to pay your attorney, and then you would have to recoup that back from the person in that situation. And it all comes down to, is that person able to actually pay you the money back?
Yeah,
some people can.
If you have the type of claim that you want to, that might result in them having to pay attorney's fees, there are certain types of claims for civil theft. Fraud, there is a fee shifting where the loser, if you can prove the person did this act, that not only do they have to pay you the money, they have to pay your attorney's fees as well. Most cases, like a negligence case, an injury case, or a property damage case, they don't have that sort of a fee shift to where the loser pays. Now, going back to what I was going to say about the small claims court, the process is actually, it's very easy when compared to dealing in circuit court or even county court. They have forms available at the courthouse. If you go down to the clerk's office, they are extremely helpful, very knowledgeable, and they can help you fill out the paperwork, and they can give you the right forms, and they can tell you what to do. We have an outstanding clerk's office. that will help you work through these forms. But they will give you a form. There is a filing fee. I think the filing fee is in small claims is what, $350 or $320?
The smallest one we deal with is when we file stuff in probate. It's $239.09. So it might be a couple
there's a filing fee of a few $100s. You can issue subpoenas. If you have a case, you can have a subpoena issued. You have to have a summons issued. A summons is the formal notice that you give to the defendant, and so that has to be served on them, either with a process server or a sheriff, with a copy of the lawsuit. Here, you've been served, and then it tells you when to show up in court, and that's when you show up and you go to the judge. Judge, this person misrepresented this vehicle to me on Facebook. I relied upon the representations. I bought the vehicle, and it's a piece of junk. And they shouldn't have done that, and I want my money back. Other side says, Judge, I thought it was fine, whatever. The judge says, okay, listen, you two go back into this room over here with this mediator, and y'all try to work it out. And most of the time, people can work out the dispute. If you owe a debt, if you're the debtor and you owe a debt, a lot of times they'll come up with a payment plan. Pay me this amount of money each month or every week or every 2 weeks, whatever you work out until the debt is paid. And they'll write it up in a mediation settlement agreement. The judge will stamp it, and there you go. Or if you don't, then you can try the case. And if you try the case, you can try it in front of a jury, you can try it in front of a judge. You will have to subpoena witnesses, you will have to present evidence, and you will have to follow the rules of civil procedure, which if you're not a trained attorney, most people don't know how to do that. And they think, well, I got a crash report, and I'll just give them the crash report. Well, guess what? That's not admissible. You know, documents that say things, you have to have that authenticated. You have to have a witness come in to talk about what it says, because you cannot cross-examine a piece of paper. There's got to be some ability to test the veracity of whatever document. So there's rules and processes you have to follow, but otherwise, you know, with the clerk's help, you should be able to something like this is something that would be ideal for small claims.
Yeah, and this one's relatively straightforward, but you mentioned something witnesses, and one of the big things when we have something that's kind of outside personal injury, whenever I'm helping a friend out or anything like that, the biggest thing that I hear is so-and-so told me this, and then there's no written corroboration or anything anywhere. When we work and we talk with an attorney on the other side, what do we do almost every time after the phone call? Per our phone call, we send them an email and say, hey, just please confirm.
Just to confirm.
And so one of the things I tell my friends, family members, or anybody, if you have any sort of agreement that's verbal, put it in writing, put it in a text, put it in an email, do something to memorialize it, and it just helps written documentation. And we do it all the time. Like I'll do it with clients or attorneys or adjusters, just to recap the conversation. So we have it in writing in case there's ever a dispute about anything, really.
Yeah, great advice. All right, folks, we're going to take the last break of the evening. We'll be back in a few minutes. Hey, welcome back. Now we're getting to the last segment of the show where we typically do our shout outs. But before we get into that, we did have a call came in. I think we got cut off on it, asking about if you're involved in a wreck and your airbags don't go off, can you sue the manufacturer for that?
So we'll be quick. The short answer is yes, but the most important thing when things like that happen is that we get the vehicle involved, because an expert has to look at it. If the vehicle's gone, totaled out, or anything like that, and it's gone, then the claim is gone. And it doesn't mean you have a case, but that is starting point number one.
Right. And a lot of times the injuries really have to be fairly significant because litigating against auto manufacturers is extremely expensive. There's a lot of expert costs involved as well. So if you have an issue like that, best contact an attorney to ask them about it. All right, quick shout outs. Who you got?
All right, well, I'm going to steal a couple of yours as always. Miss Pam, I'm taking credit for all the fish that we gave you, even though Les caught most of it last weekend. But shout out to Miss Pam. I know Captain Brad is watching, Jimmy, Kim, Kayla, Nicole, Donna, Harry and King, David at K-Halls, and then Rick at the Marlin, I'm sure, is watching as well.
Yes,
but
sir.
I know you got a list too,
Yes,
so
sir.
I'll give the floor to you.
I'll give a shout out to my mom and dad. Welcome home. They went up to the ARC experiment up in Kentucky. So welcome home, Mom and Dad. My daughter Rachel, son Eli, my wife Jen. My boy had his prom this weekend with his beautiful girlfriend Bennett. They had a great time. A shout out to my neighbors Jamie and Ed, my friends Nick and Lauren, and I think we got a couple pictures up there that Larry had sent into the show. All right, so that's Larry and his wife Pam and Miss Delaney Gray. Delaney is Vicki Gray's daughter. Vicki is our legal nurse, and she's stunningly beautiful in that photo. And there's another picture right there. That is Miss Tony. She is a friend of our friend Pam Myers, and I hear she's a heck of a singer too. So I want to give a shout out to those folks as well, and thank you all for watching. So I think that's pretty much it for the night. We appreciate everybody tuning in and making those phone calls. We'll be back here the same time next week with another topic. Neither one of us will be here because we are both going to be out of town, but somebody else will be in these seats, and go easy on them.
Yeah, have a good week.